May it please your lordships, I appear with Miss Rogers on behalf of the appellant, whom I shall refer to as Tesco. Mr McGilroy and Mr Pickington appear on behalf of the respondents, whom I shall refer to as the claimants. Could I start by asking your lordships to look at the order from which this appeal is brought? It's in the core bundle, tab 4 at page 37. Your lordships will see on page 37 there's a penal notice. That is, in my submission, significant. And if we go to page 38, your lordship will see two declarations. First of all, there is set out the wording of the contract providing for retained pay, and I'm assuming your lordship is well aware of the purpose and nature of retained pay. So it sets out in paragraph 2.2 the contractual provision, which its common ground were incorporated into all the affected employees' employment contracts. And then in paragraph 2.3, it is asserted that on the proper construction of those terms, the word permanent is that subject to the four principles set out in the retained pay term, the eligibility for retained pay endures for as long as the employee continues to be employed in the substantive role in respect of which he or she is currently entitled to retain pay. So there, her ladyship found that the provision for retained pay meant there was an enduring entitlement that extended beyond the life of the contract which generated it. And then, my lord, in paragraph 2.4, there is the implied term which her ladyship found was required to be implied in order to give effect to that point of construction, an implied term whereby the right to terminate, which of course would otherwise be unfettered as in any contract of employment, cannot be exercised for the purpose of removing or diminishing the right of that employee to receive retained pay. Now, your lordships be aware this agreement relates to employees employed at 3 distribution centres in England. And these terms were agreed with the individual claimants that are parties to the appeal back in 2007. Lord, then we come to the injunctive relief, and if I could pick it up at paragraph 3.2, the defendant, that's Tesco, shall be retained from directly or indirectly, first of all giving notice to terminate the contract of employment under which the affected employee is employed, contrary to the implied term of that contract, whereby the right to terminate cannot be exercised for the purpose of removing or diminishing, as your lordship sees. I'll skip over B for the moment, although I will note as I do so that B was addressing a situation that wasn't directly raised by the facts of this case. There was no attempt to do anything other than give notice as provided for in A. So that B dealt with a problem that actually didn't arise in this case. And then 3.3, there's a clause that appears to be clarificatory. For the avoidance of the above orders do not preclude the defendant from dismissing any affected employee for reasons wholly unrelated, directly or indirectly, to the removal or diminution of retained pay. So directly or indirectly, this is an injunction which will last for several decades. All 3 of the individual claimants are in their 40s. One of them is only 40 years of age, and the normal retirement date for these parties is 65. So we're looking at something like 25 years duration plus in relation to at least some of the employees. The clarification in paragraph 3.3 appears to suggest or indicate that if dismissal is influenced in any way by retained pay, by considerations of retained pay, it's prohibited. So Tesco's directors and its managers are at the threat of sanctions for contempt if any contract is terminated in circumstances where there is any argument, room for any argument, that the decision to dismiss was influenced in that way. Let me give some examples. The redundancy example perhaps would be the best one. Ability to invest in technological advances means that Tesco is able to close down some of its distribution centres. In deciding which centres to close down, it inevitably will take into account that some centres are more expensive to run than others. In other words, it inevitably will take into account that at some centres, some members of staff are in receipt of retained pay. In that situation, it is being influenced, or at least taking into account, a consideration which relates to the removal of retained pay. So it would seem as if that scenario would be in breach of the injunction. Or if one takes another redundancy situation, where the centre stays open, but because of technology and investment that's made, it's possible to reduce the size of the workforce. Then Tesco is faced with a choice as to which employees to select from the pool. And again, it takes into account the fact that some employees are more expensive than others. Both of those situations would appear to represent a breach of the order and thus a contempt of court. Now, in my submission, that is a remarkable result. It operates as a very serious constraint on how Tesco can conduct its business. And yet, it springs from an agreement that's about pay, not about dismissal. So, why? My submission is that her ladyship came to that conclusion as a result of, first of all, failing properly to construe the express terms in the contract. Secondly, failing properly to apply or take into account the principles governing the implication of terms. Thirdly, inappropriately treating the situations arising in a narrow series of cases, starting with the decision of Mr. Justice Sedley in 1997, as being directly analogous and establishing a principle which is directly applicable to this case. And fourthly, drawing conclusions and issuing an injunction which is not internally consistent and is issued on an incorrect basis. If I could start by dealing with the express term issue, the judge's conclusion as to the meaning of the express terms are critical to her conclusion that it's necessary to imply a further term constraining the right to terminate on notice. The key passages of her ladyship's judgment are at paragraphs 37 to 40. Perhaps I'll give your lordships a moment just to read.
Before we look at the judge's judgment,
yes,
can you just show us the original document which is referred to in paragraph 2.2 of the order?
Lord, yes, it's in the core bundle at page 91. It's tab 8. I was going to come to this later on, as your lordship no doubt expected, but if your lordship picks it up at page 75, these are pay and condition terms for one of the distribution centres, Lichfield, but it's common ground they apply to all of them. And your lordship will see at page 76 there's an outline of contents, basic hourly rates, premium payments, drivers, other payments, and so on, holidays, sick pay. This is a contract, this is a set of provisions that it is the product of a collective negotiation process, and it's relating, as your lordship will see from page 75, it's about pay. And your lordship will see that the index indicates page 17, site-specific arrangements, brackets, retained pay. If your lordship were to move on to page 91, your lordship sees the set of provisions.
But this is not part of any individual's contract of employment.
Nor it's common ground that it is.
Right, but by what route did it become part of the individual contract?
Lord, I would need to take specific instructions.
Please do.
But my understanding is it would be because of custom and practice, but that may not be a sufficient answer for your lordship. Implied incorporation as a result of custom and practice, my lord. But that is not an issue between the parties.
No. Thank you.
But if we could start with the individual contracts.
So just to be absolutely clear, you say you accept that what we see at page 91 of the core bundle is to be taken as read into each of the individual contracts of employment.
My lord, yes. I don't know if it reinforces it, but your lordship will see how it's provided for in an individual contract. Let me show you that. If one goes to supplemental bundle, tab 7, page, starting at page 34. This is Mr. Kumar's contract. Mr. Kumar being, oh dear, this is, it's the fourth claimant. I should have known that already. It's agreed in, your lordships will see,
I thought this was
September
Mr. Singh, not Mr. Kumar.
I'm so sorry.
Isn't this Mr. Singh, not Mr. Kumar? No. They're the same. At 44.
34.
34.
Oh, 34, sorry. They're the same anyway. Oh, yeah.
The individual contracts are not all identical, but for present purposes, there's no suggestion there's a difference. Your lordship will see location. You will be based at Daventry 1. It's one of the three centres. If it goes over the page 35, under the heading pay at the top of the page, your rate of pay will be, and then there are several hourly provisions, rates set out, and at the bottom of that list, there's weekly retained pay, £218.75.
Yeah.
That's the only reference to retained pay in this individual contract of employment, and it's accepted that that reference incorporates what's at page 91 of the core bundle.
And just to be absolutely clear, lower down that page there's a reference to an addendum that has nothing to do with anything. I don't think we've got it, but that's got nothing to do
the addendum for this contract is missing, but there is an addendum for Mr. Kumar's contract, which I'm going to show you for completeness. I know of no reason to think that it would be materially different. I'm gratified, I don't know whether it's appropriate for me to express gratification for the fact your lordships have clearly read the papers. Page 36, you're halfway down the page, notice, if you want to leave the company, or if we end your employment, details of notice periods required are given in the attached addendum. So there is a provision for mutual right to give notice of termination. And then the Lord, just for completeness, at page 37, any changes to the details provided in these documents will be communicated to you personally. That, I would suggest, is an indirect reference to the collective negotiation process by which these contracts can be amended. And then, my lord, your lordship asked about the addendum. Perhaps I should go to that, page 42, behind tab 9. This is Mr. Kumar's contract.
Page 42.
It starts at page 42, but the addendum is starts at page 45.
42, this is why I was confused. 42 is Mr. Singh.
I'm so sorry, did I say Kumar?
Yeah, yes, and if you look at 43, there's a different provision about retained pay in his terms and conditions from Mr. Kumar. So I thought you were taking us to Singh, that's why I was confused, because page 43 is a very different form of words from the one you've just shown us.
Well, Lord, it is a different, as I adverted to a few moments ago, it is a different form of words. We say not materially different. It doesn't result in there being a different set of rights and obligations in relation to retained pay for Mr. Singh.
Well, it seems to have been common ground below, reflected in the judgment, that each of the individual contracts of employment for claimants incorporates by reference the document beginning at page 75 of the core bundle, and in particular the retained pay clause at page 91.
My lord, yes. And your lordship will also say at page 43 at the bottom there's a provision for notice, that's notice of termination. And if we go to the addendum, the relevant addendum in relation to termination is page 47, and it provides in the normal way, if you want to leave the company, please give the following amounts of notice, and then the notice to be given depends on time of service. If we end your employment, you will receive the following notice, except in cases of gross misconduct, when you will receive no notice, and there your lordship will see provisions 2 years but less than 3 years, 2 weeks. Then 1 additional week of notice for each completed year of service up to a maximum of 12 weeks. So in this case, all of the relevant individuals will have 12 weeks notice of employment. Now, I should at this point emphasise something which your lordships will be well aware, that as a matter of contract, the employer can terminate on notice for good reason, for bad reason, or
Yes.
for no reason at all.
Yes.
That's firmly embedded in our contract law. It is, of course, qualified by statutory rights under, amongst other things, the Employment Rights Act, and I'll come to that in due course. But as a matter of contract, it's trite law. It doesn't even need to be written down. If a contract is silent about termination, the court implies, the law implies, I should say, an unfettered right of termination on reasonable notice. So,
But that goes to remedy rather than liability.
I'm not sure I understand the way that your lordship puts the question.
You've drawn our attention to the injunction, and you say the injunction is contrary to principle because it prevents the company under potential contempt sanctions from dismissing these claimants. But the fact that there is generally a right in the employer to terminate the contract doesn't mean that terminating the contract is therefore, by definition, not a breach of contract.
My lord, what it means is, in order for what would ordinarily be clearly an unfettered right of termination, for good reason, bad reason, or no reason at all, there has to be found another term in the contract making it unlawful to exercise it either at all or for some specific purpose or for some range of purposes.
Yes.
So I do accept that. I mean, the target at which I'm tilting today is the judge's decision to imply a term which constrains what would otherwise be an unconstrained right of termination. And I say that's a large thing which is highly unusual and it can only properly occur in quite narrow circumstances, and our circumstances are not amongst them.
But if you lose on construction, it must follow. If there was a permanent right in the sense that so long as you were in that job, you got that salary, then the implied term arguably becomes easier to put in. You might want to say the fact that you've got to imply a term and the fact that the contract would read normally if it was retained pay for the benefit of this contract, but it could be terminated and there'd be perfect harmony within it, is relevant to construction. But in terms of if you lose on the construction argument, you can't apply a term, that's going to be much harder, isn't it?
Lord, if I lose on construction, it depends. I don't want to be difficult, but it depends what you mean by losing on construction.
But it means what the judge said it meant.
If there would then be a question is, how does one deal with that construction, and does one imply a term? In cases where something has gone wrong such that the parties might agree that it is appropriate to apply a term, that is not an end of the inquiry. One then has to determine what specific term needs to be applied. And there it needs to be clear that there is one contractual solution and one contractual solution only. So even at that level, I would be submitting to the court that there is no such certainty. It's not clear what term ought to be applied. All that is clear is that the judge's term shouldn't, in my respectful submission. That would itself be a barrier for implication. But as I say, I'm tilting at a slightly different target for the moment.
I know you haven't got there, but one might wonder whether really there is an implied term argument at all. One might wonder whether really this is just a question of construction. How, looking at the contract as a whole, do you construe the contract? Do you construe the notice provision as unfettered? Or does the fact that you also have the provision for retained pay to be a permanent feature mean that it's fettered? And that's just a question of construction, not one of implied term.
Well, Lord, I'm sure Lord Hoffman would be nodding very firmly in relation to that. I do say that implication is required. I say on construction, I say two very simple things. First of all, I say a contract provides for benefits to be provided during the currency of the contract. Generally speaking, it doesn't provide for benefits provided after the currency of the contract. One would need very clear wording indeed to produce that result. An example would be post-employment restrictive covenants. There you would have an example of a contract which specifically provides that even after it's terminated, these rights continue. Absent that clause, there is no basis for reaching, in my submission, that conclusion. It would be an extraordinary thing to do. So that's my first submission on construction. My second submission is, in circumstances where one of the express terms is a term which by its very nature is unfettered, you need something which operates as a fetter on that unfettered right. And that can only operate, in my submission, by means of an implied term restraining it. And
it's not quite as you put it there. I mean, it says if you want to leave the company or if we end your employment, and then the addendum says if we end your employment. It doesn't of itself say anything about are there any circumstances when we can't end your employment. It simply says if we end your employment, assuming you can do so under the contract, then you've got to give the requisite number of weeks' notice.
Well, that provision is all under the heading notice. What does notice mean, I ask rhetorically? It means notice of termination. What that wording is talking about is the notice that each party has to give in order to terminate the contract.
Yeah.
And it's to be construed alongside the well understood principle of law, the well established principle that I've already sought to advert to your lordships, which is that all contracts of employment where there is a right to terminate on notice, it is a right to terminate for good reason, bad reason, or no reason at all.
Normally, yes, but if you've got an unusual situation where the contract has put something in about guaranteeing for the rest of your employed life in that job, then it might be one of those unusual situations where you construe it. You may not have to, as my lord says, imply a term. When you read the if we end your employment with the retained pay, you may well arrive at the same result.
Well, my submission would be not, much for the reasons I've already suggested to my Lord Justice Newey, but there is a further point. The further point is, if your lordship were right, if I can respectfully put it this way, about the meaning of the express term, it would apply in circumstances where a claimant is dismissed, terminated by notice, and then rehired in the same job. But it wouldn't apply if the employee is dismissed simpliciter. The effect of this judgment is to make it contrary to, in breach of contract, to dismiss simpliciter, whether the person is rehired in the same role or not. And indeed, it's to impose an injunction, imposing an obligation backed by the sanction of contempt on Tesco if it has the temerity to do that.
Well, let's put the injunction to one side for a moment. I quite see why, I understand the points you make about the injunction. As I said earlier, that goes to remedy. The question seems to me in this case, it's an easy one to state, but not an easy one to answer, is the contract consists of, say, the very standard notice provisions in Mr. Kumar's or any other one else's contract, plus the retained pay clause, page 91. They're to be read together as a single contract. What do they mean? And would it be a breach of contract for your clients to dismiss these claimants?
Lord, the retained pay provision says nothing about continuing employment. Even if your lordship were to subject the relevant wording to the construction, it applies even if the contract has been terminated, but there's been a re-engagement such that they perform the same role, which was the question that my Lord Justice Newey asked me about. In that situation, one can understand why it might be said that the contract provides that if there were to be a re-engagement, it should be on terms for that retained pay is included. But if there is no re-engagement, then in no circumstances there is nothing to stop. It simply provides, that the contract simply provides, if I can just go to the wording. Retained pay is individually calculated and confirmed in individual statements of employment. It is an integral part of contractual terms. Now, stopping there, what does that mean? What that means is you have a contract. This provision for retained pay is an integral part of that contract, not another contract.
No.
Then it goes on to say, and it's included in calculations for pension and other benefits. Then it provides, retained pay will remain a permanent feature of an individual's contractual eligibility subject to the following principles. Now, what does an individual's contractual eligibility mean? In my submission, the answer to that question is obvious. It means the eligibility under the contractual terms that have just been mentioned in the previous sentence. So where it says it will remain a permanent feature of the individual's contractual eligibility, it means that where you've got a contract which makes you eligible, it will remain, you will remain eligible under that contract for so long as the contract subsists. In my submission, it's not an available or a sensible construction of this contract to construe it as providing for the fact that there shall be no dismissal.
Well, that indeed is the central issue in the case. Do you accept, as Mr. Carr did before the judge, that if you're right, it would have been entirely lawful in terms of common law breach of contract for Tesco the week or the month after the claimants moved to a new site to say, right, here's 4 weeks' notice or 12 weeks' notice, or whatever it is you're entitled to, goodbye?
My Lord, yes, but subject to a very, very important caveat. This contract is to be construed by reference to and in accordance with the context within which it was made. An important part of that context is the Employment Rights Act. If you'd asked if you'd asked USDAW when they were negotiating this agreement, or an employee when he's signing his contract of employment, does this deal with Tesco sacking you? In my respectful submission, they would say no. Tesco would certainly say no. And you would then ask, well, what about, couldn't you be sacked on day one? And they would say no, because I'm protected by statute. If the dismissal isn't for one of the specified reasons in section 98, if it isn't for some other substantial reason of a sort which justifies dismissal, and what's more, if it is for some such reason, if it isn't the reason, the decision to choose the reason as a reason for dismissal isn't reasonable, determined in accordance with justice and the substantial merits of the case. These are words which your Lordship will be far more familiar than I. Well, then in those circumstances, the Tesco would be liable for substantial sums. And if it were, for example, having induced all the staff to rejoin the distribution centres, it were to sack them on day two, it would be subject to liabilities which outstrip by a substantial margin any of the redundancy payments those people would otherwise have been entitled to. So this is not a case where dismissing on day one or year one or year two or year three would be something that could be done that would trigger no sanctions. There would be a substantial sanction. It would be something which an employer would be very slow to do. And the existence of that sanction, the fact that it would be a very expensive thing for the employer to do, is a reason not to imply or to put into this contract an extraordinary obligation, or alternatively to read the contract as qualifying what would otherwise be a trite right of an employer to give notice of termination for any reason. To do that would have an extraordinary result, and it would not be required because the contract itself, when operating in accordance with the intentions of the parties, and which includes the operation of the Employment Rights Act, well then there is a meaningful a commitment being made by the employer, because in the real world it's not going to happen. You then move forward 15 years. We're now 15 years since the individual claimants entered into their new contracts of employment. 15 years later, you ask, does this provision still apply? Now, 15 years later, it might well be the case. There are all sorts of excellent reasons why, in fairness and justice, it would be appropriate for the employer to think, do you know what? I didn't want to do this, but now I've got to a point where I need to terminate these contracts in order to manage my business. Because there comes a point when construing the clauses as your lordships have been discussing, or implying a term as I've come to address, it would have the effect of impinging substantially onto the business freedom of Tesco, of actually preventing it from managing its business in an appropriate way. And so I would turn the question around. You don't just look at this problem from the point of view of the employee, you also have to look at this problem from the point of view of Tesco. I'm an officious bystander now, it's back in 2007, and I say to Tesco, do you accept that by entering into this agreement, you're fettering your power to determine in 15 years' time to give notice of termination of these contracts in circumstances where you have a substantial reason justifying submission to do so, and it's reasonable for you to exercise that right. And in my submission, that would be an extraordinary construction to arrive at, and it certainly wouldn't be something that Tesco would ever have agreed to. I hope your lordship will forgive me, I'm terribly hoarse today.
Not at all. While you pause for breath, can you, something I meant to ask at an early stage, what has happened to the Scottish litigation? We have the interim interdict. Have matters gone on from there?
My understanding is that I'm looking around, that the proceedings rumble on. There is no end date for them. Pleadings have closed. Would your lordship give me an answer?
Yes, of course.
Yes, pleadings have closed and no trial date has been scheduled.
Goodness me. Right.
Going back to the meaning of the word permanent, another feature, one of the features which is common ground and which your lordships absolutely should take into account when construing this contract, is that retained pay provisions were designed as an incentive to persuade members of staff to continue working for Tesco rather than taking voluntary redundancy, and I don't shrink from that at all. Another feature, which was also an important part of the context, and indeed is common ground, is that a problem about which the parties were concerned was the impact of the collective negotiation process that had been agreed between Tesco and USDAW. Lord, that's referred to by Ms McGuinness, a national officer of USDAW, at paragraph 30 of her witness statement. Can I ask your lordship briefly to go to it? It's at page 173 of the supplemental bundle.
How does that help us understand the meaning of the contract, the witness statement?
Lord, it's not that Ms McGuinness is giving evidence of subjective intentions. That would be an inadmissible evidence.
Oh, so we're looking at it for something else then?
Yes,
Okay.
I'm looking at it as evidence of a problem that was concerning the parties when they entered into this contract.
Yes.
And if your lordship will go, it's behind divider 18, page 173. It's at the bottom of that paragraph. It could not be negotiated away either by the defendant or the first claimant. The rationale behind the latter stipulation, that is, the concern that would generate...
Where are you? You said the bottom of that paragraph. Which paragraph?
Paragraph 30, I'm so sorry, Madam.
30, right. The amount of various agreement was there would be a permanent future.
I didn't understand this part of the evidence. Of course, with the passage of time, the retained pay group would tend to diminish, and they might in time be outvoted in a ballot. But so what? Surely the fact that a ballot is held on a collective agreement and the majority are in favour and the minority are against and the union agrees to it, that doesn't of itself change anybody's contract of employment?
Lord, it's common ground in this case that it would.
Why?
But my answer I think would be...
I thought collective agreements are by statute not legally binding on anyone unless they say they do, which they say they are, which they never do. So why does it? Why would it not be open to Mr. Kumar or Mr. Singh or any dissenter to say, I'm not happy with this collective agreement. I decline to agree to give up my retained pay. If you want to take away my retained pay, you'll have to sack me or take the consequences.
Well, I'm going to give you two answers,
yes.
one of which is a weasel answer, but it's true. And that is that the parties, at the time this contract was made, that is what the parties believed to be the position. And, my lord, it's what they still believe to be the position. They believe, my instructions are, that this is the fact that once you've had a ballot, it will operate so as to require each employee to have a change to its contract of employment. Your lordship will have seen the provision in the individual contract I showed you, which is changes will be notified to you. Well, what changes? They're changes that were achieved via the collective bargaining process provided for in the collective bargaining contract agreement with Asda, in which perhaps I could take your lordship to that contract. Would your lordship give me a moment?
I think it was page 37 you showed us.
I'm thinking of the collective agreement itself.
Oh, I see.
It's at tab 11 of the supplementary bundle, but thank you, my lord. Your lordship will see this is it's page 49 of the supplementary bundle. This is a recognition and procedural agreement for the three sites, Livingston, Daventry 1 and Lichfield. I should say Daventry, I think Daventry 1 includes both Daventry sites, not Livingston, that's in Scotland. And if we could move on to page 51, your lordship will see recognition of membership. The company recognises Asda as the sole representative and negotiating trade union for staff below the grade of team manager. So there the trade union is representing the staff in negotiations in relation to their contracts.
Yes.
And under the heading union membership, the company and Asda relationship has developed over many years, resulting in full recognition, procedural and negotiating amendments. All effective staff and members of Asda, I add parenthetically. And if your lordship goes over to page 52, under the heading changing terms and conditions of employment, that it sets up a negotiating body known as the new contract at JNC. I apprehend JNC stands for Joint Negotiating Committee.
Yes.
And then, Lord, over the page at page 53, there are to be annual review meetings. The JNC shall meet in due time to ensure negotiations can take place and be agreed prior to the anniversary date of the agreement. What negotiations, I ask rhetorically? It's negotiations about individual contract terms, amongst other things. And then at the bottom, third paragraph down, additionally, the JNC may also meet to discuss matters of direct and mutual relevance outside the framework of the annual negotiations. And then at page 54, under the heading negotiating process, the JNC shall meet with a view to reaching agreement on the items that will then be placed before the union membership for ballot. The items will be presented in the form of agreed joint statement and supported by some form of joint report. And then under the heading joint statement, communication of the decisions of the JNC shall be agreed by signed statement. And then under the heading agreement process, perhaps I could ask your lordship just to flick your eyes down. Subparagraph C, there's a provision for voting in the ballot. And under the heading on that page, rejection of proposal, should the JNC not be able to reach a agreement or in the event of a rejection, the JNC will meet again to determine how the matter can be resolved. Well, what does that provision mean? It means that if there is a ballot, if there is agreement between Tesco and Asda, and a ballot then approves it, There's nothing more to resolve. And that then triggers the provision which I showed your lordship in Mr. Kumar's contract, which says you'll be notified of changes to your employment.
Yeah. So I suppose you say, even if the position is that such changes are not binding on the individual employee, if the individual employee rejects it, that's a bit of a lawyer's argument, because in real life the individual employee would not or would consider it a very serious risk, and that's likely to have been what was in the minds of the parties in 2007.
Lord, I would go further. I welcome what your lordship has said, but I would go further. We know it was in their minds because it's addressed specifically by Ms. McGuinness and indeed by Ms. Fulks in her witness statement. And she was the national officer who was involved in the negotiations for the Livingston site.
Right. Thank you.
So if I can, against that background, go back to page 91 to the contract itself. I may already have made these submissions to your lordship in answer to some questions. Let me make sure I have. Middle paragraph. Retained pay is an integral part of the contractual terms. Stopping there, what does that mean? Is it's an integral part of this contract. While this contract remains in effect, it remains integral. It's not saying after this contract's come to an end, it's in some mystical and metaphysical way, it continues to remain integral. So that middle paragraph is entirely consistent with my submission, which is and it's what you would expect when a contract provides for a benefit. You would expect the benefit to be provided only so long as the contract continues in existence, like pay, like guaranteed bonuses, and like other things. And then we go to the next paragraph. Retained pay will remain a permanent feature of an individual's contractual eligibility. What does that mean? It means once it's in the contract, as it is now, it won't be removed from the contract. And why is it necessary to say that? I mean, I'm posing the question that my Lord Justice Bean just asked me a few minutes ago. It's necessary to say that. The parties cannot unilaterally effect changes to this contract. Tesco can't do it on its own. Asda can't do it on its own. But there is a process by which Tesco and Asda can get together and agree changes, and then following a ballot, those changes then get notified to the individual employees. What this is saying, by saying it will remain a permanent feature, is that even if that happens, it won't impinge on this term. This term is a term for pay protection, and it will endure, if I can use that word, that's another word for permanent, enduring. It will endure, notwithstanding an attempt to change it via the collective negotiation provisions that I've just shown at the court. And Lord, that is common ground. That is what Ms. McGuinness says in her witness statement. It is the basis upon which the argument below proceeded. And indeed, it was accepted by her ladyship in the course of her judgment.
But mutual consent here means mutual consent of the individual?
Yes.
Tesco?
So that's precisely right. If one then, just to put the icing on the cake, one then goes to the four provisions that are the conditions or the principles that are established, set out there. All of them are principles which are only applicable really while the contract subsists. On promotion to a new role, well, that's something that can happen. You've got a contract, you're employed, and you're promoted. So that's something that characteristically will happen during the continuation of the contract. When an individual requests a change in working patterns, that's the kind of thing that will happen during the ordinary operation of the contract as it stands. If Tesco makes shift changes, again, these are things that happen during the life of the contract. And then going back to subparagraph 1, the one that my Lord Justice Bean asked me about, retained pay can only be changed by mutual consent. What that means is that although retained pay can't be changed by the collective bargaining process, it can be changed by individual agreement with individual employees. And that is the principle that Tesco sought to invoke in 2021 when it invited the affected employees to agree to give up their retained pay in return for a benefit, for a payoff.
And just so that I've understood, to make sure that I've got the whole of your case, I understand that what you say is this means it's part of the contract of employment you've got and it doesn't continue beyond. Even if you wanted to change or read differently to look at a permanent feature of an individual's contractual eligibility, that could only mean if you retained a contract of employment, if you had a contract with them, then it had to be put into that contract. But you say that on any analysis, those words can't mean and you can't dismiss and can't be forced to continue to have a contract. And that's why you say they've got to get an implied term for that as well. I
always feel uncomfortable when a judge puts words and puts things in ways that perhaps I wouldn't. I think I'd like to agree with your lordship, but I'm slightly wary, which is says more about me than
generally not a trick question.
No,
I know it sounds odd, but we're trying to do what's called justice.
Yes,
we're trying to work out what it means, and
yes.
that seems to be the way that you're construing it. It really means this contract. It's a part of this contract, and that's the end of it.
It's a permanent.
But even if you were to say, well, contractual eligibility doesn't actually mean eligibility under this contract, it could. I was thinking to myself, well, if they change the contract and they put them on a new contract, but it's the same job, they could still say, well, that contract has got to have it. And because of the question I asked at the beginning, that still is really tying it to a situation where you have a contract, and by definition, if you terminate it and you're not re-engaging, there wouldn't be a contract, which would be part of.
My submission to your lordship, and I hope I'm intending to grapple with your question, is that these provisions are only talking about one contract, namely the contractual terms referred to in the middle paragraph.
Exactly.
Those contractual terms are the terms that are entered into when the retained pay was agreed.
But if you're against you on that, it can only refer, on its wording, to a situation where there is a contract of some sort to which it can be put in. And if you have a power to terminate, then there may be no contract at all. And that, you would submit, I imagine, throws light on what it was intended to do and mean. It can't have been intended to mean forever, because it's only ever tied to a contract of employment and there's nothing to limit the termination.
One commonly says, do you have a permanent job? Are you in permanent employment? Yes. What does that mean? I have a contract of employment which will continue until such time as it's terminated in accordance with its own terms. That's what. So in the ordinary contractual sense, permanent only means that. It just means it's something that's not variable during the life of the contract. So I know I'm setting up the question in a way that's favourable to my case, but in my submission, this is an illuminating way of looking at it. So you look at these provisions and say, is permanent here used to convey anything different? And the answer is yes, it was. It was supposed to add something, but we know what it was supposed to add. It was supposed to ensure that during the life of the contract, the collective bargaining process couldn't take these rights away. What was required during the life of the contract was individual mutual consent between an individual employee and Tesco. And so to the question, might the third paragraph talking about contractual eligibility be referring to eligibility under some different contract other than the contract referred to in paragraph 2? In my respectful submission, there's no basis for thinking that it was.
No, I understand that. That's your main case, as I said. But then the next question that I was asking myself was, even if somebody thought, and even if it was meant to mean, so long as I've got a job with Tesco, I'll get my retained pay, that still doesn't solve the problem. What happens if they exercise their power of termination? Because then they don't have a job with Tesco. So the permanence can only be tied to the existence of a contract, not a power to bring about the end of the contract, is what I was putting as your alternative.
My lord, yes, I do respectfully say that there has to be a contract. And the question is does contractual eligibility there, the phrase contractual eligibility implies eligibility under a contract. Does it mean the contract? Does it mean any contract? So does it mean what happens if an employee resigns, goes to work in another city for 5 years and then comes back, applies for a job and gets a job in exactly the same role that he previously had? Does that mean he's entitled to retain pay? That, in my submission, that question only needs to be asked to be answered. Obviously not. The whole purpose of this mechanism was to incentivise people to stay with Tesco. If they've gone away and then come back again, it would be bizarre in my submission for the contract to give a contractual entitlement where the incentive no longer applies 5 years later, maybe when circumstances may be completely different.
Right, where do we go next?
Your Lordship will give me a moment. I've submitted to your Lordship that both as a matter of natural interpretation and as a matter of common sense and as a matter of contractual purpose, what this contract is what these terms are talking about are entitlements to retain pay under the contract which confers those entitlements. My Lord, I ought to just mention that the judge herself accepted that that was the natural construction. And that's at paragraph 39 of her judgment, which is at page 56 of the core bundle. Permanent is a word of common usage. In the contracts with which I'm concerned, its use in relation to retain pay might, devoid of context, be considered to confer an entitlement which is permanent for as long as the particular contract endures, other than in specified circumstances with which I'm not concerned. Well, my respectful submission, she was right to say that. But she's even right to say that if one takes into account the context. The context is, first of all, when you come to a contract which provides for a benefit, you only expect that benefit to be provided during the life of the contract. There has to be something said, there has to be some special reason to construe the contract as providing for a benefit after its termination. Secondly, we know what permanent was intended. It's permanent. The addition of the word permanent added something. It's common ground that it added something, which is that it protected the entitlement under this contract to any attack via the collective bargaining process. And thirdly, we have the contextual point, the point that I've adverted to Lordships too, that if someone accepts a job with retained pay, then 5 years later, when circumstances are completely different, he leaves and goes somewhere else, and then 5 years after that, when circumstances are even more difficult, are the parties really to be taken to have intended that at that point a new entitlement to retained pay would spring up out of nowhere? My respectful submission is obviously not. So the judge was right, but she said in paragraph 40 that to adopt such a construction would be to ignore the intention of the contracting parties in this case. In my judgment, a reasonable person having all the background knowledge which would have been available at the time when the clause was incorporated would have understood the word permanent in such a way, having regard to the context in which the clause was drafted. True it was, she says, that the intention encompassed an intention to remove an entitlement to retain pay from the collective bargaining machinery, which would otherwise admit of the prospect that it could be removed at the will of the majority who did not benefit from it. But that was not the full extent of the intention, she says. It is clear from the undisputed evidence in this case that the mutual intention of the parties was that the entitlement to retain pay would be permanent for as long as each affected employee was employed in the particular role, save in the circumstances expressly articulated. Now, she refers to evidence. In fairness to her, she wasn't suggesting that there were any subjective declarations of intent or any negotiation documents that are admissible as an aid to construction. What she meant was these collateral documents that she referred to much earlier in her judgment.
But you say, well, you draw a distinction there, but why are those admissible on construction? I mean, as you say, she says there's no other way in which to make sense of the use of expressions such as guaranteed protection for life, and in particular for as long as you're employed by Tesco in your current role. Now, those are not contractual phrases. They're found in extraneous documents. And why are they admissible on the construction?
I want to say two things in answer to your Lordship. I'd love to embrace what your Lordship has said, obviously. It's a question to which an easy answer would help me. These other documents are clearly no substitute. It's important to remember that what's being construed are the words of the contract, nothing else. But it appears to be the case that during the process of negotiating the retained pay, and before the ballot took place at which retained pay was approved by the majority, such that it was then offered to the individual employees, the individual employees would have been told things of the sort that were said in these documents. Now, these documents weren't actually shown to the individual claimants. There's no evidence as to who saw what, and that is highly unsatisfactory. But I don't...
Sorry, is that correct? The key phrase, really, is in paragraph 10 in that document, 20th of February, for so long as you're employed by Tesco in your current role, and you've got arguments about that means current role under the contract of employment.
Yes.
But was this part of the process of negotiation, or was it something that came after it being negotiated, and it was telling employees what would be in there? And if it's the latter, what's the relevance of that to interpretation?
Well, your lordships both ask an extremely fair question, and I'm now beginning to doubt perhaps my condescension in accommodation. The answer is this. Strictly speaking, let me make a submission that's not in my skeleton argument, and let me apologise to my learned friend for not having articulated this before you asked me a sensible question. As I understand it, as I understand the evidence, the agreement was made between USDAW and Tesco without the benefit of those documents. The individuals at USDAW and Tesco who made the agreement would not have been relying on those documents when they did so. These were documents that were either reported to employees during the negotiations, or they were perhaps shown to employees before they voted on the outcome of the negotiations.
Well, that's clearly so, isn't it? Look at the judge's paragraph 9. Defendant provided its employees with a compensation package summary, setting out in tabular form entitlements, etc. For those who chose to remain in employment, it was said, there would be new terms and conditions supported by individual retained pay, protection for life at new Tesco contract site. That said, that was provided by Tesco to individual employees.
My lord, let me then clarify my submissions yet again. The true meaning, the true construction of the collective agreement that your lordships have seen at page 91 should not be construed in the light of those other documents. That collective agreement was made by USDAW acting as a representative for the individual employees. So I'm terribly sorry not to have made this submission in my skeleton argument as I should have done, but I am driven to the conclusion while on my feet that these documents are not admissible as made construction. My submission was going to be there are no weight, and they don't substitute. There are no substitute for the contractual words, but actually I realised that had I been properly rigorous, I would have embraced a rather stronger proposition. They're not even admissible as aids to construction.
I mean, were they post-contractual, which they probably aren't, they'd be irrelevant because they're post-contractual. If they're pre-contractual, they're being used to cast light on the parties' subjective intentions as a means of construing the contract. And one would have thought that that was permissible.
We know that's not allowed. Yes. I'll explain my thinking. My thinking was the agreement would have been made between USDAW and Tesco. There would have then been a voting process, as a result of which the agreements would have been incorporated into individual contracts of employment. I now, having thought about it properly while standing on my feet, I had thought that it was possible to construe the agreement by reference to these other documents because they would have been taken into account by the employees when they were voting on whether or not to approve these terms. I realise, of course, that the question whether or not their voting was valid or would have depended on whether they were deceived. It would have depended on matters that had nothing to do with the true meaning of the agreement or with whether what they were told was consistent with the true meaning of the
Well,
But even supposing that the contract, so to speak, is formed at the later stage when they voted, you're still using what has been said before that point to cast light on subjective intentions in a way that surely isn't legitimate.
Well,
I mean, it might come into estoppel or something, but I don't quite see how it comes into construction.
Lord, I don't want to go too high on this. There's abundant authority for the proposition that where you have a contract with explanatory wordings provided with it, then the explanatory and the party then signs it with the benefit of the explanatory wording, then the explanatory wording can be used as an aid to construe the main contract. So if that were the proper analysis, it would be admissible as an aid to construction. It would not be a substitute for the terms. And in my submission, given the flimsy nature of these documents, it wouldn't be very weighty aid to construction.
why
But
not?
what
Why
I
not?
hadn't appreciated, and I should have, is that these aren't explanatory documents which are given to a putative contractual party so that he can decide whether or not to sign the contract. That's not how it worked, and I should have thought more clearly.
Why do you say it's not how it worked? If the judge's paragraph 9 is a true statement of what happened, that's exactly how it worked.
If these documents can be seen as documents that were intended to be explanatory to the parties who were about to enter into them and were relied upon by those parties in entering into them, then I would accept that it is admissible as an aid to construction. But only if all of those conditions are satisfied. Not
Well,
that they...
what are they then? Because we need to know whether we can or cannot look at them first, and then we need to know what they mean. And this says on the 20th of February 2007, staff will provide with the QA. The actual agreement comes 4 paragraphs later, 3 years later, on the 18th of February 2010. So do I or do I not look at these documents to interpret the contract?
May I take instructions very briefly? I'm so sorry to take time. Lord, the hearing below proceeded upon the pragmatic basis that this material could be relied upon as an aid to construction. The dispute between the parties was how it could be relied upon, whether it was of any weight, and whether it could be used as a substitute for the true contract. I don't want to resile from the position.
So is your submission that if parties pragmatically do something, it's an aid to construction, or is your submission that we treat them as explanatory documents of the sort that you've outlined?
It's the former, my lord.
Yeah.
If your lordship disagrees with me, then I can't stop you from saying I'm wrong.
Pragmatism doesn't seem to be a useful, helpful basis for construing documents. Anyway, there we are. That's what you say.
If I could go very briefly to the documents, time is going, so perhaps I should just go to some of them. If I could ask your lordship to go to the supplementary bundle and look behind divider 1. This is a document that would have been sent by Tesco to employees. And your lordship will see the first paragraph, dear colleague. Colleague is a term of art. It refers to Tesco employees, Tesco members of staff. You will now be aware that we have concluded our discussions with your representatives and have reached a point of agreement that we all feel is the best position we can provide, following a very long and detailed process. This process now provides you with 2 options, retained pay or redundancy. Then there's a thank for the help of the team. Third paragraph, we have secured a process that will protect the value of your existing contractual terms and conditions for the remainder of your contract with Tesco.
Mine says for the remainder of your employment.
Tesco.
Not contract, but isn't that Freudian slip?
That was
important.
That was a dead giveaway, Lord, and doesn't help me. But interestingly, you asked forensically, does that mean any employment or employment under this contract? Obviously, it means employment under the contract that you now have a choice of accepting. Enclosed with this letter is the following. 1, 2, and then 3, copy of questions and answers from the briefings. The Tesco team have been consistent throughout that the new contract is key to enable Tesco the best way of operating Livingston. This is a Scottish document, and any new distribution centre. At the same time, your representatives have been determined we protect the value of the current T&Cs for existing staff. And then this penultimate paragraph, perhaps your lordship should read that.
And the date of this document?
This is, I believe it's January 2007. And it's to do with Livingston, which is a distribution centre in Scotland, not one of those here. And then page 2, about halfway down, it's under the heading Questions from Briefings commencing 21-107. Question 6, will retained pay be guaranteed forever? Answer, yes, providing your circumstances do not change. See question 7 and answer 7. Question 7, what will happen to retained pay if I move from one shift to another? And there's the answer. So you can see that what they're talking about is how the contract will operate. And then question 8, why change the contract if we're not losing any money? Answer 8, we want to introduce the concept of retained pay to ensure there is long-term protection for you. Making retained pay an individual contractual entitlement prevents any possibility of this being subject to negotiation or change in the future via a ballot of the membership of which existing staff would be in the minority. Retained pay ensures that this will never happen. So, Lord, to the extent that this is an explanatory document, what it explains is the provision for retained pay, the provisions about permanency and so on, are designed to ensure that the collective negotiating process can't take it away during the currency of the contract concern. And going back to will it be guaranteed forever, that obviously can't be taken literally. No one would have meant that. Nor can it mean the situation that I suggested previously of a man accepting a job, working there for 2 years, leaving, waiting for 10 years, coming back and end up fulfilling exactly the same role.
You say nobody could have intended it to remain forever, but then what about the statement, the joint statement, Asda and Tesco, Lichfield, 23rd February 2007. The retained pay is guaranteed for life.
Well, Lord, one of the things that needs to be borne in mind is these documents contain phraseology which can't possibly be read or it can't possibly have been intended to be taken literally. If your lordship
but don't
goes
they indicate that it's not intended, whatever it means, and we've got to work out what it means. It's not obvious that it meant for that contract of employment rather than employment under any contract, for example.
Could we go to that very document, to page 7 of the same bundle? Under the heading Compensation Package Summary. I've no idea what the provenance of this document is. I've no idea why it's produced, but what I do know is it's like a flyer. It's the kind of thing that might have been put on a notice board.
Yes.
And it says, what do I get if I move to Lichfield or any other Tesco site with the new contract? New terms and conditions supported by individual retained pay, protection for life at new contract site. Now, the notion that this flimsy document could be taken to have engaged in a subtle analysis so as to make it clear that what this guarantee doesn't merely exist under the new Tesco contract, which is actually what this document's all about, but actually extends to any future document, that contract that may ever be agreed.
But this is the document that the judge relied on, is it?
Well, my submission is that she was wrong to attach any weight to this document at all. It plainly is not intended to be the kind of document that substantial reliance should be placed on. And your lordship will see that from the bottom of the page. It says at the bottom, please refer to previous joint statements for details. This is not the document upon which any decision is supposed to be made. It's some kind of heads up, some kind of, I don't know what it is, but it isn't, in my respectful submission, it has no weight at all, and it certainly can't be treated as a document that is embarking upon a very subtle and nice analysis of giving answers to the sort of questions that that we are discussing at the moment.
But I'm sorry, but the judge doesn't rely on this document, does she?
No, I'm answering a question that was asked by my Lord Justice Bean. And,
Well, I was looking at tab 5.
tab 5.
Just before you move to tab 5, I suspect the judge does rely on this, doesn't she? When she says in paragraph 40 in the middle, there's no other way in which to make sense of expressions such as guaranteed strict protection for life. I think protection for life is taken from this document. Because if you look at the first box, it says protection for life at new Tesco contract.
Yes. Oh, I'm so sorry. Yes, perhaps I should have made that clear. These were the documents. The reason why they're in this bundle is because they're the documents which we believe on this side of the court the judge was relying on in coming to a conclusion. But did your lordship say tab 5?
Yes, tab 5 is judge's paragraph 11 recites the relevant paragraph from this, which is described as a joint statement published by the defendant and the first claimant, Tesco and Asda.
So your lordship will see, second paragraph down, the company opened a meeting. So these are notes by Asda of a meeting attended by Asda and Tesco. The company opened the meeting by explaining that this would be the first in a series of consultative meetings designed to ensure that all issues raised by CRIC staff are addressed and responded to. The following points were discussed, and under the heading Lichfield, in order to protect the existing employees, staff who transfer to Lichfield will be entitled to retain pay. This is an arrangement which is designed to protect the difference between the value of the employee's current contractual pay and the proposed contractual pay at the new site. This excludes casual overtime. The retained pay is guaranteed for life and will increase in line with any future pay increases. Retained pay also counts for the purposes of calculating benefits. At the next meeting, further information will be provided to explain the exact method of calculation. So your lordship will see that that this is a sort of running a series of discussions with the staff. This is one of several meetings. The next one from page 28, your lordship will see, was to be on the 5th of March. Again, it's not the kind of document which it even purports to embark upon a subtle analysis of the juridical significance of payable under this contract or payable under any contract should you come back years later, or should you have a new contract in which you happen to fulfill the same role. And in my submission, it's just these sorts of documents, given the evident purpose for which they were prepared, simply don't bear that level of subtle analysis, and they shouldn't be subjected to it as the judge did.
It's not very subtle, is it? The retained pay is guaranteed for life.
Well, in my respectful submission, if a man takes a job, works for 2 years, goes away for 10 years, and then comes back 10 years later when the circumstances are completely different, and where the staff now working at the distribution centre are paid on completely different terms, it would be amazing if your lordship were to treat this document as being conclusive to the question whether he should continue to enjoy retained pay or not.
What about this case and these claimants who haven't done that and have worked for 15 years, whatever it is, 13 years under these terms, and they want to carry on working under these terms? The first question is, do they indicate that it's under the contract that exists at the time of the adoption of the collective agreement, or does it cover any future contract, or is it in effect a promise to keep them in employment and to pay them the retained pay during that employment, whatever the contract? That's the first question. And you say, oh, they're all too broad, or they're all basically manifestos of an election, and who would believe them anyway, and we can't put any weight on them. Yes. But say you're wrong on that. Say we think, oh no, this is quite clear. When it says for the remainder of your employment, it meant employment, not employment under this specific contract, but also employment under future contracts, such as fire and re-engage. I still don't understand, I'm afraid, what your submission then is about the documents.
Well, my lord, if I'm to submit that my submission is wrong, I don't have any further submission. But my submission is...
There's only weight. They are admissible. It only goes to the weight and the meaning that they have.
They may be admissible. This one looks as if it is. The first one certainly looks as if it is admissible. It's an explanatory document. But it's not a substitute for the contract. You can't do what the judge did, was treat this wording as if it was in the contract itself, The wording that's in the contract itself is the wording that's on page 91. And it's really important in my submission to understand and accept and recognise the supremacy of the contractual language used. There's only so much that an explanation can change. The second point is that when you come to look at the explanation, you have to take into account the sophistication and the level of sophistication and the purposes that were of the analysis underlying and the purposes of the relevant explanation. What the parties were doing in this case was trying to convey that once you've got this contract, it can't be taken away by collective bargaining. We know that was a concern because that's addressed in the document that's at tab 1. And that's what these words mean. They're very loose ways of expressing that very simple idea. And to try and subject these words to the kind of nice analysis that it would be appropriate to subject them to were this a 90-page partnership deed that's been drafted by Slaughter and May, in my respectful position, would be completely wrong. It's just not the purpose of these documents. You can't use these documents to rewrite the wording of the contract itself. This was a collective agreement. The parties who made that agreement knew very well what they're doing. These are very impressive people, and very capable people on both sides. And they aren't to be taken not to have meant what they said by virtue of these much looser documents that are being written by people I don't even know who these people are. And if one goes very quickly through, if your lordships go to divider 2, another example of the looseness of these documents. This is an USDAW document. It's got a heading summary. Your USDAW Shop Stewards Committee and senior USDAW officials believe the proposed settlement is the best deal that can be achieved. It sets out the principles. Second bullet point, guarantee protection of these arrangements. So it's rather like protection for life, isn't it? But it then explains what it means. They cannot be altered by Tesco, USDAW or USDAW Shop Stewards in future negotiations at the main site. The protection they're talking about is protection from the collective bargaining process. And then if one goes over the page, it is on this basis that the Shop Stewards Committee is asking the membership to unanimously support. And then USDAW encourages all members to consider the full details of the proposed retained pay settlement. So again, they're referred to another document that is more detailed, probably including page 91. And if one goes to tab 3, we've already seen. As I say, this is the kind of document you pin on a notice board. Yeah. Behind tab 4, it's the CRIC document. And my lord, it's questions and answers. I believe this is a document that was prepared by Tesco, your lordship will see from page 9, to its managers. And it was a briefing document for them to use when discussing matters with individual employees. So this isn't what employees were specifically told. If your lordships go to page 15, it's question 33. What does retained pay mean? If you transfer to a newly opened site, you will be on a new contract. However, any difference in value between your old contract and your new contract will be protected by the concept of retained pay. Stopping there, it's interesting that they're noting about the difference between the old contract and the new contract. They're not talking about a third contract that might be entered into at some point in the future. These words cannot possibly relate to a rehiring contract.
Just pursuing that for a moment, I wonder whether that's a real problem, because in the case of your person who resigns, goes away for 5 years and comes back, well, page 91 says that you can take away retained pay by mutual consent. And at the point at which Tesco and the returning employee agreed a new contract, they could perfectly well agree to take away retained pay by mutual consent.
I'm sorry, but yeah, I would say my answer to that question is yes, but I'm not sure the answer.
I mean, if you have your hypothetical returning employee, he wants a job back at Tesco.
Yes.
He has to agree with Tesco a new contract of employment.
Yes.
If that says no retained pay, well, page 91 doesn't bite, because page 91 says you can take away retained pay by mutual consent.
But in that scenario, I think her ladyship would say, well, hold on, he's got a contractual right. The whole point of her construction is the contractual right to retain pay continues even after the termination of the contract, such that should a new situation arise where he's negotiating a new contract, he can say, in this negotiation, chaps, I have a contractual right that trumps any of our negotiations. You must give me retained pay.
And that I find, were that what was at issue, I'd find that puzzling. I mean, the real problem might be the dismissal in the first place.
The real problem might be?
The dismissal in the first place. I mean, if an employee simply resigns, fine. If later on he comes back and agrees a new contract, well, page 91 doesn't seem to bite because mutual consent has dealt with the problem. So the real question seems to be, is it legitimate to fire someone at the start?
Lord, it really is, I'm in danger of repeating myself, and I should be careful not to do that, but it really is important to understand that on the true construction of page 91, the contract did not give any employee who was no longer employed the right to demand retained pay should he come back and with a view to performing the same role. So the right to retain pay, it follows by logic that the right to retain pay ends on when the contract ends. Now, if the right to retain pay ends when the contract ends, I then address your lordship's question, well, doesn't that mean that somehow it's improper for the contract to end? There's some constraint on the ending of the contract at the instance of the defendant. And I have two answers to that question. The first answer is, well, no, because the contract, the provision for the benefit of retained pay only lasts so long as the contract lasts on its true construction. It says nothing, it's about pay protection, it's not about employment protection, it says nothing about the circumstances of dismissal. And then I'd go back, and these are the points I'm going to address your lordship on implication of terms. If you were to, the officious bystander were to ask both USDAW and Tesco, and indeed the employees, is Tesco to be taken as giving up what would otherwise be a very firmly established legal right to give notice of termination at will? Tesco would say, of course I'm not. There are all these good business reasons why it could be very damaging in 15 years' time for me to do precisely that. And so the question then is, why would you construe the express terms of the contract as having that effect in circumstances where those express terms say nothing about termination? They don't impinge upon termination. The collective agreement is about pay. It's not about the duration of the contract. It's not, as I say, it's pay protection. It's not employment protection. I hope that's an answer to your lordship.
Yeah.
I see that time is moving on. I wonder whether the transcribers may need a rest.
Yes, by all means. Shall we just break up? It's 7, goodness me, 7 minutes to 12 by mine, 22 minutes to 12 by the court clock. So let's take a 7-minute break.
Court rise. As an original, so get to say, does that make sense? That's what I was thinking. Okay. So maybe these are new.
Membership. Newey's definitely right. Lewis is difficult to know where he's coming from. He says, assume you're wrong, and then what do you say?
Do you get me? Because otherwise, if you change it, you might get double judges. A whole lot of game, unless you've copied the file regardless. So judge Wayne's Newey. Yeah. So we should change that to 21. What we do at the end is we change it. Right, okay. Does that make sense? Yeah. Looking at them. Lewis.
Well, you try to say, well, that wouldn't be mutual. He was just exploring it. You deleted it, not the last one. So they've now got to write this grand difference between someone choosing to leave and then coming back, and someone who doesn't choose to leave but then is reemployed. How can you do that over language? Yes. Came out rather nice. Aching allergic in my feet. I don't do problem. The agreement does say you're represented.
Yes.
Unless they're acting in breach of warranty.
You can change the speaker so far, don't worry too much. There's always a comment now. Yeah. I'll just do a quick. Yeah. So, 16. Next to me. Newey. Over there. That's right. Yes, is it? Thing is, because you can't stop it, it's going so fast.
Is it there? Is it right there?
Yes.
My lord, I'm afraid I'm behind in my submission, so I'm going to skate rather faster than I had intended to. I'm now going to address your lordship. I'm going to proceed on the basis that I've finished on express terms.
Yes.
And I'm now going to address your lordship on the question whether it is necessary to imply a term, any term at all, or in particular the term that the judge implied. Of course, the leading case is Marks and Spencer. I appreciate your lordships will be so familiar with this. It will be rather tiresome to go back to it, but it's such a good guide. Could I ask your lordship to go to the Bundle of Authorities, Volume 4, behind tab 37?
Yes.
Small point, worth adverting to the facts very briefly. This was to do with early termination of leases, and the question was, once you terminated a lease between two quarter dates, and given that rent was payable in advance, was there an implied term requiring the landlord to pay back a portion of the quarter's rent that had been paid in advance, because otherwise it would be unfair and it wouldn't work. The Supreme Court held no, there is no such implied term, and it's worth adverting to the reason why. It's at the bottom of the page, heading 2. It was that there was a well-established, clear, general understanding that the rent was not apportionable in time at common law, and that was the critical factor. And I do advert your lordships to the well-understood, clear, general understanding about the right to terminate on notice being for good, bad, or no reason at all. But if we can move on to the principles, perhaps I could ask your lordships to go to paragraph 18, which is at page 753. This is a citation. This is where Lord Neuberger sets out the classic citation of the 5 principles in BP refinery. And it must be reasonable, equitable. It must be necessary to give business efficacy to the contract so that no term will be implied if the contract is effective without it. It must be so obvious that it goes without saying. It must be capable of clear expression, and it must not contradict any term of the contract. Your lordships will be very familiar with that. And then on paragraph 19, there is in my respectful submission, a really helpful discussion of, I'm not saying this for practical reasons, but the masterful analysis of law implied term by Sir Thomas Bingham in Phillips Electronique. And I'd invite your lordships to read paragraph 19.
Yes.
That makes clear a point which is really important, and in my submission is highly applicable to the circumstances of this case, is that there are times when the law should not wade in implying terms, because if the parties had been put to the question what should happen in situation X, they might well not have agreed. There may be a good reason why there's not an express term dealing with the point, because the parties would have had very different understandings of what was to happen in that situation. And for reasons you'll appreciate from my submissions already, I say this is precisely such a situation. If your lordships could then go to paragraph 21, you will, I'm sure, be very familiar with Lord Neuberger's, I think, 6 comments, but I'd ask your lordships to remind yourselves of those. I would draw 2 points particularly to your Lordship's attention. First of all, fairness and fair and equitable, necessary condition but not sufficient. It is a necessary condition. It's another way of saying court may not think a contract works very well, for example in the way that it allocates risk, and thinks there's room for improvement. But that's not a reason for implying a term. It's actually, properly understood, a reason for not implying a term. And the not necessary to work as probably intended. The last comment of Lord Newberger is generally thought of as emphasising how strict the test is. There was a time when it was thought to be slightly laxer, but namely, the contract would lack commercial or practical coherence without it. That's a high test. So you may think, a party may think, well, this doesn't work very well for my interest. I'd much rather if it gave me this benefit, because this benefit, it does give me some benefit, but it's not nearly as good as I would want. Of course, the other party has a very different attitude. That is not enough to justify a term. You've got to say that without the implied term, the operation of the contractual scheme, of the provision, is so meaningless, it's so poor that it bears no practical coherence. And that is a very high and exacting test in my submission. And if I could ask your Lordships to move on to paragraph 29, which is at page 757. This is where Sir Thomas Bingham emphasises the strictness of the requirement of necessity, and I make no apologies for repeating a point which I'm sure your Lordship already have well in mind. To bring your Lordships up to date, no changes in the law, but this court has relatively recently considered the law relating to implication of terms. That's behind tab 42. It's a case called View Designs. It was a case where there was a contract for the design services for flats that were being developed in Singapore. The designer enjoyed a basic fee plus commissions on ultimate sales that were achieved by a specified deadline. There was then a property crash, so the sales weren't achieved by that deadline, and indeed the flats all ended up being let rather than sold. The designer unsuccessfully sought to imply a term that the owner of the flats, the developer, was required to sell them within a reasonable time. If we pick it up, it starts at paragraph 47. In paragraphs 47 to 49, there's a summary of Marks and Spencer, which I needn't delay your Lordships with. Then in paragraph 50, it's made clear that there are recent cases upholding Lord Newberger's approach, emphasising that the term must be capable of clear expression. And then, if I could ask your Lordship, and perhaps you'll see Lady Justice Carr's summary at paragraph 51. Maybe you'd prefer to read that in your chambers.
Well, there's nothing new in this, is there?
My Lord, no. I would advert your Lordships to paragraphs 54 and 55. Your Lordship need not read them now, but necessary to give effect to intention. The intention that's required is an intention as to there being an obligation, not an intention as to how the people are actually going to act in fact. And then paragraphs, again for your Lordship's note, paragraphs 72 to 75, the important point that arises out of there, this it really comes at paragraph 73 and 74. The judge was correct to take the view that the parties would not simply have answered "oh, of course," and that it was highly unlikely that the officious bystander would have been testily suppressed. As he commented, there would have been heated discussions. Lord, I say the same thing in this case. I do not repeat the difficulties involved in agreeing to sale within a reasonable time, and so the lack of obviousness in such a term being agreed. Beyond that, it's not for this court to second guess what, if any, discussions might have flowed from the officious bystander's question. It is enough to conclude that there was no clear and obvious single answer which would have met with both parties' approval. The question would have given rise to a host of alternative options and connected considerations, and Lord, I say that applies in this case exactly. So that's the general principle. Could I now take you to particular agreements, in particular collective agreements? I can ask your Lordship to go to Bundle 1, tab 13. Ali and Christian Salveson, Food Services, a decision of this court in 1996. I don't have time to take your Lordships to the facts, I'm not sure it's necessary, but at page 726, the paragraph beginning by the letter C, Lord Justice Waite says, "The circumstances which are in my view crucial to the present case are that this was a collective agreement negotiated across a broad front for a substantial labour force." Stopping there, that's true in this case too. It represented a carefully negotiated compromise between two potentially conflicting objectives. The desire on the one hand of the employees to have an assured rate of weekly pay spread over a long period, and the desire on the other hand of the employers to avoid the high cost of paying overtime for work done at periods of peak demand. So again, carefully negotiated compromise. That's true of this case too. It is in the nature of such an agreement that it should be concise and clear, so as to be readily understood by all who are concerned to operate it. That's true here. One would expect the parties to such an agreement to set their face against any attempt to legislate for every possible contingency, should there be any topic left uncovered by an agreement of that kind, that is, a collective agreement. The natural inference, in my judgment, is not that there's been an omission so obvious as to require judicial correction, but rather than the topic was omitted advisedly from the terms of the agreement on the ground that it was seen as too controversial or too complicated to justify any variation of the main terms of the agreement. Lord, I, for reasons which would be obvious, I pray that approach in aid in this case, in the case of this collective agreement. Lord, as to, that deals with relevant context, relevant agreements. As regards contracts providing for rights that can be exercised at will, perhaps I could ask your Lordships to go back to Bundle 4 and look at Lewison. It's tab 46. It's behind the second red divider page. If I could pick it up at page 929, and I'd invite your Lordships to read paragraph 17.104 through to 17.109 on the other page. So, as well as there being what might be called a strong reluctance in the courts to read things into collective agreements, there is a strong reluctance in the courts to read things into unqualified contractual rights. And that's true both in the employment and in the commercial context. There is in this bundle a highly illuminating article written by Mr. Justice Foxton. I don't have time to take your lordships to it now, but I would invite your lordships to read it. It's behind tab 45 of this bundle. It is extremely interesting, and I rely on all of it. But your lordships may find pages 361, 370, and 371.
Just a minute, you're going too fast.
361.
This is tab.
It's tab 45, and it's pages 361. I really don't have time to go to it down. 371 and 375 to 383. Now, there are cases where the unqualified, the unfettered right to dismiss has been subject to implied terms. Nothing until the late 1990s. But the claimants now say a principle is well developed, established over the last 25 years. But what has been established over that period? Two situations only. The first situation, which you will have seen from the skeleton arguments, is the PHI disability cases. Well, had I had time, I'd have taken your lordships to the first case, which was Asda, which is at in bundle 1 at tab 12. But the point in these cases is that where a party has, an employer provides for a contractual benefit of the provision of disability benefit or PHI insurance in the event that the employee is unable to work through sickness, well, the courts take that to mean that where the employee is unable to work for a long time through sickness, of course, other things being equal, dismissal will be likely on the question of, on that very ground. But where there's a promise of a specific contractual protection against that very eventuality, of an if-then sort, if you qualify for a sickness benefit, you will be paid the sickness benefit, the whole purpose of that provision will be undermined. The whole purpose of that provision is that you should be paid that benefit when you are unable to work, and that purpose is frustrated if it's possible to dismiss on the very ground which qualifies you for the benefit, namely on the very ground that you're unable to work. It makes obvious sense in that very narrow situation that when an employee is sick and has an accrued or is accruing a right to benefit, in other words, he's either qualified for his sickness benefit or he's about to qualify for his sickness benefit, then in those circumstances there will be an implied term preventing the employer from dismissing him on the ground that he's unable to work. It's a very rare case, and it's a very modest qualification to the generally unfettered right to terminate on notice. It applies only to a few employees when the right is accrued or has accrued or is accruing. And it's a situation where there is an inconsistency of the contractual scheme in the express terms of the contract. Well, that's explained in the case of Reader and Flag, which is in bundle 2 at tab 22. Perhaps I could ask your lordships to look at that. This was a case where there were two employees who were on fixed-term contracts, I believe, but the contract was terminated early, just before they would have qualified for some stock options, and they argued for an implied term that the court should that it wasn't that the right to dismiss was qualified by an obligation not to exercise it when they were just about to qualify for some stock options. Perhaps I could pick it. They relied naturally on Asda, and if you pick it up really at paragraph 48. And then 49 and then 50. If you could, your lordships could read the balance of the page.
And 51.
Indeed. And of course, the passage I rely particularly on is the last couple of sentences of paragraph 51, where Lord Millett said, but even if the case is taken as a rare example of a term being implied into a contract to qualify an express right, and I emphasise the word rare, the justification for this course lay in the need to reconcile express terms of the contract which were mutually inconsistent. No such problem arises in the present case. So, need for an internal inconsistency for which an implied term is necessary to resolve. Lord, there's been a series of later cases involving sickness benefit and disability benefit which have adopted a similar approach to that of Mr. Justice Sedley. It's worth mentioning, though, that the one difference in the approach is that the implied terms have been made. These are all implied terms in fact. None of them are legal. These are not legal incidents of the contract. Every case depends upon the wording of the particular contract and the context within which the contract was made. There is a case in which an attempt to imply a term in this context was failed. And that's a decision of Mr. Justice Silvers sitting in the Employment Appeal Tribunal, in a case called Lloyd and BSQ, and that's in the bundles at 3 tab 33. And this is implication in fact, not implication in law. It's worth noting that as the cases have progressed, the circumstances in which, well, the formulation of the implied term has changed. So in Asda, the implied term was that you couldn't take PHI cover away unless you terminated for cause, which Mr. Justice Sedley treated as a repudiatory breach by the employee. In the later case of Hill, which is in file 2 at tab 16, the court uses the formulation termination for reasonable and proper cause, and indicated that would include not just repudiatory breach but redundancy. In Briscoe, that's file 2 at tab 20, Lord Justice Potter's formulation was save for a cause other than ill health. In Genvy, which is a case I'll come to, Justice Elias referred to save for good cause. In Lloyd and BSQ, Mr. Justice Silber endorsed the Briscoe approach of reasonable and proper cause. He also tentatively suggested that dismissal for absence from work would be a reasonable and proper cause. And in the most recent case, a case called Awan, Mrs. Justice Simler took the opposite approach. Rather than saying you can't take it away unless you're terminating for cause, she said that dismissal is prohibited where it's on the ground of sickness. In other words, if you can't dismiss on the ground of the very event that entitles you to the benefit. And one can see the justice of her approach. But in all those cases, there are two consistent features. First of all, they only apply in the very narrow factual scenario when the employee is not working because he's sick and he has accrued or is accruing a benefit entitlement. So an employee who's not sick, the implied term doesn't apply to him.
I can understand that. I understand on the facts of those cases, sickness was there, but is there some principle of the common law that you're saying it can only apply in sickness cases?
Well,
and where it's analogous, if you were to interpret this as saying this is a clause which says you will remain employed and whatever contract of employment you're on, you'll get the retained benefit. Why isn't that analogous if that's what it means?
Well, Lord, first of all, in a sense, all payments due under a contract are you're entitled to those payments unless and until the
But
contract
this is a different
comes to an end.
situation. They were trying to get them to move from I forget where to go to somewhere else, and they didn't want them to be made redundant. They wanted them to be there, and they say you'll get a special payment, the retained pay. That's the context.
Yes, did your lordship just refer to January? I didn't hear what you were...
No. You're saying every contractual entitlement is the same, but this isn't quite the same because it was dealt with to address a specific situation. And the question, why isn't that analogous to... it's not an answer I'm saying to say, well, it's just a payment under a contract. The answer is this may be a special payment for special reasons.
All of those cases recognise that the employer should retain control over its business affairs. The employment contract, the contract relating to one sick employee should not affect the way that the employer conducts his affairs. The specific mischief that the implied term is designed to guard against is where the employer both has the right to terminate for ill health and has the obligation to pay a benefit in the event of ill health. And that creates a special inconsistency which generates the necessity of an implied term to resolve it. The present case is nothing like that in my submission for a large number of reasons which I'll come to in due course, if your lordship would give me a moment. The most recent case is Awan, and it's only right your lordship should see that case. It's in bundle 4 of the Hyde in tab 39. If we could pick it up at paragraph 28, which is at page 704, your lordship will see the nature of the benefit that's provided for. This is a good illustration of the approach adopted by the courts nowadays. At G, headed long-term disability benefits, the booklet said, and then about 5 or 6 lines down, the disability income will commence 26 after the start of your absence. It will continue until the earlier date of your return to work, death or retirement. So there you have a very clear contractual provision that a benefit should be provided for a very clear contractual period. I add parenthetically, you don't have anything like that in this case. If we then move on, her analysis of the cases starts at paragraph 41 through to 45, but perhaps the key point arises in paragraph 46. These cases support the arguments advanced by Ms. Cunningham that where the employer has made a contractual promise to cater for long-term incapacity for work by conferring valuable disability benefits on employees according to an established scheme, the whole purpose of the scheme would be defeated if the employer could bring an end to such entitlements by dismissing employees when they become unfit for work and have accrued or are accruing benefits. Employers who wish to retain such a right would need to use particularly clear words in their contracts to do so, and even then may not succeed, as happened in Asda itself. So your lordship will see that it's a very narrow situation where there's a contract that says when situation X happens, you are entitled to this benefit. And in those circumstances, the court says, well, when situation X happens, that's the one situation when you can't exercise your unfettered right of termination, because it would defeat the purpose of the contractual scheme.
Well, Mr. Gilroy is going to say this is absolutely bang on point.
Well, I would strongly submit that it's not for a number of reasons. Let me come to those.
Yes.
First of all, in my submission, it's not right to start with the Asda line of cases. I haven't gone to Genevieve, but I apprehend that it's not necessary for me to do so. Your lordships are clearly familiar. It's not right for me to start with the facts of those cases and then work back with a view to explaining why they don't apply to the present case. What your lordship should do is start with the wording of this case, the contractual wording of this case, and apply the rules so as to determine whether or not it is appropriate to imply a term. But if one does look for differences, here are the differences. The most obvious one is that it's not within the factual scenario contemplated in those cases. And while this is not an empty point, when one is dealing with intrusive and potentially far-reaching questions of fettering the important right of dismissal, the court should tread very carefully. Secondly, there is no conflict in the terms of the contract needing to be resolved in this case. The judge, in my respectful submission, was wrong in her approach to the word permanent. But even if she was right in her use of the word, her approach to permanent, if Tesco doesn't actually want to keep an employee in the role, why is there an obligation, I ask forensically, on Tesco not to terminate their employment?
Well, the answer is surely to the rhetorical question, if we were against you, and if they were promised that if they did do the move and go to Livingstone or wherever, they wouldn't lose out, and they'd get a formula retained pay which would make sure they wouldn't lose out, and they would get that whilst they were employed and would continue to be employed. To try and get rid of that benefit by sacking them instead is analogous, is what's said against.
In my respectful submission, that's not the case at all. It's not analogous because the whole purpose of let me pause for a moment. If a term of that sort were to be implied, it would be implied for day one. It wouldn't be a case that it only arises when an employee becomes sick, when the employee actually satisfies a particular condition. It would apply from day one for 20, 30 years.
Yes, because the nature of the promise is different because of the fact.
It would apply to a very large number of staff. It would affect Tesco's ability to manage its business, because it would affect things like whether it can close down sites, whether it can select people for redundancy, whether it can determine on the remedy of wrongful dismissal in cases of gross misconduct. It can affect all of those things in circumstances where, had you asked Tesco, hold on a second, at the time, are you willing to give up your right to manage your business by exercising your right to terminate for any reason or no reason at all? Tesco would obviously have said, no, I'm not. There would have been a negotiation. This is not the position in the Asda line. This is not the position in Genevieve. There would have been a negotiation. And Tesco would have said, hold on a second. I'm not giving you some protected status. This affects the way that I manage my business. For example, what happens if in 21 years' time I'm subject to equal pay claims? Even a pound an hour difference between what I'm paying staff in distribution centres and what I'm paying staff somewhere else could have a huge impact on my business. Is it really the case? In those circumstances, it may well be the position that I would qualify as having some other substantial reason for dismissal, and it may well be the position I would be acting reasonably in choosing it as a reason for dismissal. And an industrial tribunal may well find that applying equity and the substantial merits of the case, I've acted unimpeachably. Am I really to be taken to agree that I can't do that in that situation? In my respectful submission, clearly Tesco wouldn't have agreed to that. We're in exactly the situation that Sir Thomas Bingham was discussing in Philips Electronic, and that Lady Justice Carr was discussing in those paragraphs in New Design Services. In those precise situations, it's precisely because one party has a very different attitude from the other that is a barrier to the implication of a term. The court doesn't have a free rein to do what it thinks is reasonable. Of course, from an employee's point of view, the employee would say, well, this doesn't work very well, because if I'm sacked, if I'm unfairly dismissed, I only get unfair dismissal remedies, and those remedies are capped in the employment tribunal. But, my lord, it may be unsatisfactory, but it still works. The regime still has practical coherence. And bearing in mind that where you're seeking to say that the implication of the term is necessary, you have to show that both parties would unhesitatingly have said, oh, of course that's in the agreement. The truth is, Tesco would not have said, of course it's in. Tesco would have said, of course it isn't in. And even if in the unlikely event that Tesco would have been willing to negotiate, they would have negotiated something very complicated, full of checks and balances, quite possibly replicating the kind of protections that are currently applied under the Employment Rights Act. And the notion that all of that would be trumped because there's some implied term which prevents Tesco from managing its business, in my submission, that just is not the right way to approach this case, because it would not have been obvious to both parties that a term should be applied in the way suggested, and it's certainly not clear what term should be applied. Your Lordship will have seen from my skeleton argument that there are a number of different. There's discrimination. There's no dismissal at all unless for cause, but another one would be no dismissal unless it's a substantial reason justifying submission and we're acting reasonably. That would be well, I could see why Tesco would insist on that. And yet, none of that is adverted to in Her Ladyship's judgment. Your Lordship quite properly focuses on the question whether some term ought to be implied, but that's not the end of the exercise. The court has to be clear what term ought to be implied. And in my respectful submission, there is no such clarity in this case.
And if the officials bystander on the very first week, they've all moved now, they're all in Livingstone or Daventry, they've all been told, if you come, we'll pay you the retained pay whilst you're employed. And the very first week, somebody said to the officials bystander, they can't sack them, can they, and avoid the retained pay that way. The officials bystander would have said, no, of course not, or would have said, well, yes, of course, that's always a possibility.
In my submission, the officials bystander said, of course not, it would be an unfair dismissal, and you'd be entitled to bring a claim in the employment tribunal, and you get a basic award, and you get a compensatory award that compensates you for several years' worth of the retained pay that you've lost, which incidentally would be substantially higher than the redundancy payment that you would have given up.
The officials bystander wouldn't have said, no, of course they can't sack you, they just promised to pay you for the rest of your employment.
Well, that's interesting. Your Lordship will have seen from Marks and Spencer and the other cases that great care has to be taken in deciding what question the officials bystander asks. In my submission, the appropriate question for the officials bystander to ask is this, if there is any kind of constraint on what would otherwise be an unconstrained right of dismissal, should it continue forever? Would it still apply in 20 years' time?
You can't just focus on the next day. You say you've got to look at the whole ambit of this potential restriction, and you can't dodge it by loading the question.
Yes, it's entirely, one understands why Her Ladyship was concerned about what happens on day one. But again, in my submission, we're talking about business efficacy here, really. And business efficacy is, does it work, more or less, or is it so practically incoherent the whole thing collapses, it's meaningless. The protection is meaningless, the protection is illusory. These are words used by Mrs. Justice Similar in Awan. But Lord, here the protections are not illusory on day one, simply because had an employee been dismissed on day one, he would have had if I can use this phrase, a slam dunk unfair dismissal claim. And the damages, the award that he would have obtained in the employment tribunal would have been substantially more than the redundancy payment of £6,000 or £8,000 in the case of the individual claimants.
But your basic point is you can't just phrase the question to look at one day in one period. Your basic point is if you're asking a question about implying a term, you've got to bear in mind that term could be used over a long period of time in a wide range of circumstances, and it has to be necessary for the term to be employed for all of those circumstances.
Indeed.
That's your basic point, I think.
Exactly. You put it rather better than I would myself. The necessity has to justify the whole of the implied term. It's not enough to say there's some necessity to to imply a term, and then to imply a term that applies in situations that extend well beyond circumstances which the necessity applies to. Would your lordships just give me 1 moment?
Yes.
Lord, on the importance of taking into account the perspective of Tesco as well as the perspective of Asda and the employees, in my submission, that's what the learned judge did. She just looked at one end of the telescope. Could I invite your lordship in your chambers to read the section 8 in Lewison, which is in the bundle at bundle 4, tab 46, at paragraphs 681. Necessary for business efficacy, no implication, even if one party wouldn't have made the contract without an implied term, you still have to show the other party would have agreed the implied term testily, as it were. That's the wrong. The test in this is in the answer, not in the agreement. And then section 9, which is at page 365 of the same book, paragraph 6.97 onwards, if the parties give differing questions to the officious bystander as to whether there should be a prohibition and what the content of the prohibition should be, that's fatal to the claim for an implied term. Lord, that really, there are only a couple of small points that I need to make about the implied term before moving on to the injunctions, but I have little time left. First of all, where there's a range of terms and it's not clear which one, it has to be clear which of those is necessary, which of those would be chosen. Where there's a range of implied terms, that isn't a very good starting point for, it's a classic instance actually of where the court won't imply a term. It should be noted that the term sought to be implied in this case by the claimants has changed during the course of these proceedings. Your lordship will see from the claim form that the original implied term is now different. And it was re-amended, the claim form was re-amended on day 2 of the case to allow a different implied term to be alleged. The bundle reference is CB tab 6 at page 69. Lord, for the purposes of our skeleton argument, we have proceeded on the basis that the judge's judgment was that the term to be implied was there would be no dismissal for the sole purpose of removing or diminishing retained pay. And we get that, Lord, from paragraph 42 of the judgment, which is, perhaps I could ask your lordship to look at that. I am satisfied that it's necessary to imply into the contract of each affected employee a term to the effect that the defendant's right to terminate the contract on notice cannot be exercised for the purpose of removing or diminishing the right of the employer to retain pay. But we're not now so sure that that was the judge's intention. That there appears to be 2 rival approaches in the judgment itself, and that arises from the discussion about injunctive relief. Could I remind your lordships of what the injunction provides? It's paragraph 3.3, which is in the core bundle behind rider 4, page 39. I should say that your lordship will recall, for the avoidance of doubt, the above orders don't preclude the defendant from dismissing any employee for reasons wholly unrelated, directly or indirectly, to the removal or diminution of retained pay. I.e., if there is any indirect or direct relation between the dismissal and retained pay, then it would be caught by the injunction.
Well, that's the avoidance of doubt clause. The critical clause is 3.2.
My lord, it was intended to clarify. In fact, it creates a huge amount of uncertainty. And I should make it clear that the original version of this said, for the avoidance of doubt, nothing should preclude the defendant from dismissing for cause. And that caused problem because of the fallacy of the excluded middle. That there are circumstances where you're not dismissing for cause, but it's still not prohibited by the implied term. And this is the judgment, this is the wording that the judge alighted upon. It's worth looking back to her judgment when discussing that. If your lordships go to paragraph 58 of her judgment, she says, in the event, I've revised the wording of the relevant paragraph in order to make clear the extent of the relief granted. The intention is to preclude the giving of notice to terminate for any reason which is in any way related to the removal or diminution of retained pay. That reflects the implied restriction on the right to terminate, which I have found to be incorporated into the contract. So that raises a question. Does this implied term simply prevent termination for the sole purpose? Or does it prevent termination for any reason which may be even indirectly related to retained pay? So, for example, if you're on a redundancy situation, what if you take into account that some employees are more expensive than others, or some distribution centres are more expensive than others? That would appear to fall foul of the implied restriction on the right to terminate, which her ladyship found to be incorporated in the contract. But more, in my submission, that would be an extraordinary result. Now so there are two rival approaches, even in the judgment itself. These are not the only rival approaches. I have some others, we have some others in paragraph 24 of our skeleton, 6 others. There's a further possible term which I've already suggested to the court, which is a term which effectively replicates the constraints that would be imposed by section 98 of the Employment Rights Act, namely a substantial reason justifying dismissal, exercised reasonably, and found to be so in accordance with equity and the substantial justice of the case. You know, which of those terms does the court choose? And the answer is none of them, because it's not clear which of them both parties would unhesitatingly have said is the right one. So, Lord, those are my submissions on the implied term. Let me come to the injunction and be as quick as I possibly can. The judgment is very short on the point, paragraph 55. Perhaps I'd invite your lordships to read it. So she gives, I think it's 4 reasons. First of all, Tesco's made it clear its intention to terminate and offer re-engagement. Well, first of all, I note that the injunction goes beyond that. Paragraph 3.2a isn't limited to cases where Tesco is seeking to re-engage. And 3.2b seems to be looking at cases which don't involve dismissal at all. So the injunction goes way beyond the evidence which is relied on to justify it. Secondly, and much more fundamentally, she says there's been an injury, or there would be an injury to the defendant's legal rights to remove a significant proportion of their remuneration. I pause there to note that that injury would be financial. The question is loss. What would they have earned had they continued receiving retained pay? In each case, ex hypothesi, their claim would be a claim for breach of contract in the High Court. So it would be a claim that would not be capped by any of the provisions in the Employment Rights Act. It would be a straight claim for damages for breach of contract, for terminating for an improper purpose. Her ladyship then says damages are not an adequate remedy because they would be limited to the losses that would be recoverable for unfair dismissal. Lord, I say this with greatest respect.
That's clearly wrong, isn't it?
Yes.
When you say on the injunction, even if you lose on every other point, as it were, and the judge's declarations were right or right subject to any quibble about wording, the claimant should be left to their remedy and damages. If you dismiss them, they would be able to apply for summary judgment for damages for wrongful dismissal on the strength of the declaration. There could be no defence in principle, but the remedy should be financial, not an injunction carrying the contempt action.
My lord, yes, particularly bearing in mind the particular context of this case, namely the effect of the injunction would be to allow people to continue working for a very substantial time, in some cases more than 25 years.
Yes.
It may be that there's no breakdown in trust and confidence now. One doesn't know what the position will be in 10 years or 20 years. So that's the first thing. I mean, an injunction to restrain termination of employment is itself an extraordinary thing. Outside those limited cases where an injunction is sought to ensure that the proper compliance with the disciplinary process or inquiry process that is provided for in the contract itself, it's very rare for this kind of injunction to be granted. Sometimes in circumstances where it's demonstrated that there is a complete, there is still clear trust and confidence, and on the particular circumstances, as at the present date, it would be appropriate to continue the working relationship. But this is an injunction that will go on, as I say, for 25 years. One doesn't know what the circumstances are going to be, even in 6 months' time. But more secondly, and much more profoundly, this is a case where, on the way in which the injunction is currently drafted, Tesco is in terrorem.
Well, you've made that point. You don't have
I'm grateful. The point is that any attempt to manage, as her ladyship said, your lordship has the point, and I don't want to flog a dead horse. But her ladyship herself, in her judgment, made it clear she recognised that if Tesco is free to dismiss the cause, but of course the employees will then, employees may well dispute that they have been dismissed the cause. They may well say, Tesco's got it in for me. You know, it tried to fire and rehire me only 3 years ago. It wants to get rid of people who are in receipt of retained pay, and this is just a further, my dismissal. I may have done something wrong, but my dismissal is a result of a desire by Tesco to deal with its retained pay problem, because it's subject to equal pay claims now. And Lord, in that scenario, Tesco cannot afford to lose that argument, because if it turns out to be wrong, it will ipso facto, its board of directors and its managers involved will be in contempt of court. So it won't have the argument at all. The effect of this injunction would be to create a privileged category of employees who are effectively untouchable. And that it really wouldn't be appropriate for this court to grant an injunction which had that effect. And of course, it is worth noting that this injunction has a penal notice attached to it.
You're saying the contempt proceedings, criminal contempt proceedings, would not be an appropriate mechanism for sorting out what is in effect an employment dispute or a contractual dispute?
My lord, yes. Lord, I see it's 5 to 1. In my haste to finish by 1 o'clock, I'm sure there are a number of points that
Well, shall we break off now, and you can have 5 minutes after the break if there's some pressing point that you've thought about, or which Miss Rogers tells you you should have made this morning.
Your lordship is most kind to me, but most of all to Miss Rogers.
She can exercise the 5-minute supplementary right of audience herself. I'll leave that to you and her.
Your lordship might prefer it, but now I'm into roaring.